Okay, let's move right along. Today this is lesson 6 of Colorado Contracts and Regulations. My name's Jim McCloskey. And let's go to page 7-4. 7-4 and talk about how we can take title to properties. Look at that concurrent interest. Concurrent interest. Let's read this. An estate and land may be owned by one person in severalty. Severalty. One person in severalty. It's confusing because it has the word several in it. But it also has the word sever. You're severed from any other ownership interest. Corporations also take title in severalty because a corporation is considered an individual by the government. So, an estate and land may be owned by one person in severalty or by two or more persons concurrently. The two most important types of co-ownership are joint tenancy and tenancy in common. Let's look at joint tenancy first here. It says, all co-owners are equally entitled to the use, enjoyment, control, and possession of the land or its equivalent in rents and profits. The best known characteristics of joint tenancy is the right of survivorship. That's the biggie, survivorship in joint tenancy. Upon the death of one joint tenant, the decedent's rights pass immediately to the surviving tenants. Death of a joint tenant does not affect title, as the title is vested equally in all joint tenants rather than individually. According to common law, joint tenancy must feature 4 unities. The 4 unities of joint tenancy are time, title, interest, and possession. I like it doing with PITT, possession, interest, time, and title. Possession, interest, time, and title. And what that means is this. The 4 of us right here buy this property as joint tenants. We all have right of possession. We all have the same amount of interest. We all have 25%. We all took title at the same time with the same title instrument. That establishes joint tenancy. And the reason we did it, because we wanted the right of survivorship. If I drop dead, before I hit the ground, my share belongs to the 3 survivors. Okay? And then so they have 33 1/3% interest. Then one of them dies, it goes to the 2, they've got a 50% interest. And the last survivor, of course, has it in severalty. So, that's how joint tenancy works. Now, let's go over to page 7-6, and tenancy in common, pretty much in the middle there, B-boy, tenancy in common. Tenancy in common is an estate in land held by 2 or more persons with only the unity of possession. All 4, we buy another property as joint tenants or tenants in common. We all have a right to possess that property. We can all live there. So tenancy in common is an estate and land held by 2 or more persons with only the unity of possession. Unlike joint tenants, tenants in common may take title at different times and may receive their interest through different deeds. But each is entitled to the individual possession of the property according to their proportionate share and subject to the rights of possession and of the other tenants. Upon the death of a tenant in common, there is no right of survivorship. The decedent's interest passes according to his or her will or the state laws of descent and distribution. So one of us dies. What happens if I die without a will, but I do have heirs, I do have relatives? My estate will be settled through that state's laws of descent. They're going to say, well, he had 3 brothers, and a son and a daughter. That's who you would have left it to. So they would have determined the descent and how it's going to be distributed by appointing what? What will the court appoint?
Executor?
Not an executor. Administrator. Yeah, you appoint an executor in your will. I didn't have a will. And so they will appoint an administrator to carry out the provisions of the court, what their decisions were. Everybody following that? So if I die intestate and I have no will, because I died intestate, but I do have heirs, my estate will be settled through that state's laws of descent and distribution. They will appoint an administrator to take over what they decided to do, and that process is called probate. Probate. Now, we have concurrent conveyances. Ownership of a home by a husband and wife is usually declared by the deed to be in joint tenancy. It doesn't have to be, but it usually is. Or as tenants in common. Each has advantages and disadvantages. The automatic and immediate right of survivorship that accompanies joint tenancy eliminates some legal complications of probate in the event of the death of one of the parties. However, inheritance taxes are assessable and evidence of the death must be recorded. Joint tenancy ensures the survivor a fair share of the marital property, and the property does pass free and for the claims of unsecured creditors. Forget about that last part right there. Disadvantages of joint tenancy may arise if marital difficulties occur, or if one of the parties has obligations or responsibilities, like children, resulting from a previous marriage. The financial and tax situation of the parties may also favor tenancy in common. Although it is helpful and proper to explain the meaning of joint tenancy or tenancy in common, big star by this, the broker must never advise a client what type of conveyance is best. To do so exceeds the role of the broker and constitutes the unauthorized practice of law. So you ask that married couple, how do you want to take title? And they say, well, what do you suggest? You say, well, most married couples take it as joint tenants. You can't do that. You have to explain what joint tenancy is and what tenancy in common is and have them choose. Or have them go see an attorney. Those are your two options. And of course, what do? You explain the differences and have them choose. Okay. We talked about, so what are the three ways we can take title in Colorado? Individually, in severalty, joint tenancy with right of survivorship. The four unities of joint tenancy are possession, interest, time, and title. The four unities of joint tenancy. And the other way is tenancy in common. Now, what are the four main differences? These are the unities of joint tenancy. What are the four main differences between joint tenancy and tenancy in common? Number one, survivorship. Survivorship. Joint tenancy cannot be willed. You cannot will joint tenancy. Did everybody see why? Because as soon as I die, I don't own that property anymore. It belongs to the survivors. Joint tenancy is not probated. You do not probate joint tenancy. So joint tenancy, again, right of survivorship. It can't be willed. It's not probated. And joint tenancy must be in writing. Must be in writing. If we...
Jim, can you go over those four again? I'm sorry.
Yeah, the four differences. Survivorship. Joint tenancy cannot be willed. Joint tenancy is not probated. Joint tenancy is not probated. And joint tenancy must be in writing. Yeah?
So if it's a difference, joint tenants in common doesn't need to be in writing?
No, joint tenancy, if I leave it blank in the contract, how they want to take title is blank, they will automatically take it as tenants in common. Because tenants in common does not have to be in writing. That's our default provision. We have a couple other default provisions. What are they? There's one other we covered.
General warranty deed.
Have we covered that? I don't think we have in most of this group here. Maybe we have. In a general warranty deed, of course, what if we don't put down what type of deed we're using, it will default to a general warranty deed. Who hasn't had that yet? Several of you have, okay. Yeah, so anyways, that's another default provision. Don't worry about it. Don't write it down. We'll cover it when we get to it, okay? And the other default provision is whether we're working as a transaction broker or an agent. And if we leave that blank, we're automatically a transaction broker. That's the default provision. So those are the two default provisions we've talked about so far. Transaction broker and tenancy in common. Now, we talked about the homestead, well, we talked about the legal life estates, dower and curtsy. Dower and curtsy. And this is outdated. Some states have it, but most states don't. Mainly because it wasn't until 1920 that women were allowed to go on title on a house. 1920. And so what happened is not only did the wife not be able to go on title on the house, but to make up for it, she had to bring a dowry into the marriage too for the privilege of living in this wonderful house. So they had dowries back then too. They're still very common in many parts of the world. I guess in India they're having a heck of a time because these guys are marrying these women, getting their dowries and disappearing. So yeah.
So if a woman couldn't go on title and her husband died, what happened to?
It went to his estate, whatever that was. It went to his will, and she could not be on title. Yeah, not until 1920. We'll talk more about that when we get to contract, also in next session, actually. So now, so we talked about dower and curtsy, and the third legal life estate is the homestead exemption. Very bottom of page 7-6 and top of page 7-7. On top of 7-7, look at the A and the B. If you declare bankruptcy or you have a foreclosure of some kind, these two kick in. If you have enough equity in your house, you can claim $75,000. Or if you're disabled, $105,000. That's if you have enough equity in the house. But it's much ado about nothing. Because virtually every loan you'll take out on a property, the lender makes you give up your homestead exemption. So it really doesn't exist anymore. And that's virtually in every state. You give up your homestead exemption to get that loan on your property. Okay, let's go over to page 7-8. Talk about easements. Easements. An easement is a limited right to enter and use another person's property. An easement is what? A right to use somebody's property for a particular purpose. There's two definitions for you. Easements are a big part of our business. Every house you buy or sell will have some type of easement on it. Let's read this. An appurtenant easement attaches to and benefits the land owned by the easement holder. So, this is my property, and this is me. We talk about this in law and practice also, and I give this guy an easement into his property up here. This is an appurtenant easement. What is an appurtenance? I'll start you out. Some of you have heard this a dozen times. An appurtenance is something of value that passes with the property. An appurtenance, something of value that passes with the property, but it's not a part of the property. It's next to, adjoining, or adjunctive to it. Again, an appurtenance is something of value that passes with the property. That passes with the property, but it's not a part of the property. It's next to, adjoining, or adjunctive to it. Next to, adjoining, or adjunctive to it. An appurtenance, any something of value that passes with the property, but it's not a part of the property. It's next to, adjoining, or adjunctive to it. Everybody got that?
What does adjunctive mean?
Adjunctive, pretty much redundant. It means next to it. Yeah, adjoining it, right. Or adjunctive to it. Now, this right here is an easement going into this property. Now this is B's easement. It's something of value that will pass with his property, but it's not a part of his property. And this easement is an easement until it hits his property, then it's a driveway or a sidewalk or something. So that easement ends, it's next to his property, it's adjoining his property, it's adjunctive to his property, but it's not a part of his property. Everybody see that? Now B is the dominant tenement. Dominant tenement. Dominant tenement. A is the servient tenement. The dominant tenement and the servient tenement. So the one serving the easement is the servient tenement, the one benefiting by it is the dominant. Easy. You're going to have that on the state exam. Don't miss that question, guys. That's an easy one. And it's right under easements, and that where we're just reading in the book there. Now, different types of easements. What if I don't give B an easement to his property? In Colorado, in theory, there aren't any landlocked properties. There are a bunch of them. I've seen them. But if you wanted to fight it, Colorado has a law against landlocked properties. There can't be. So if I did not give B an easement, he could go to the city or the county, wherever the property is, and apply for an easement by necessity. Easement by necessity. Now he's got an appurtenant easement, permanent easement created through necessity. Permanent easement created through necessity. And what if that easement looked like this, where they had to go in and actually purchase this right-of-way, either through inverse condemnation or eminent domain? Now, what is this easement? It's an appurtenant easement created through necessity by means of condemnation. It's got three names. An appurtenant easement, an easement by necessity, and an easement by condemnation. Okay, does that make sense? Pretty good examples of how an easement works. Now the state might come in and find an easement up here. Who knows? That may not even affect A. Yeah, Adam?
In this example here, if that's a driveway next to A property, who owns that, and like if there's damages to that easement, who
That's what I'm saying. They have to purchase that easement by those properties that are over there.
Okay.
And they may do that through eminent domain or inverse condemnation.
Okay.
And they may have to do that. Remember, because there's not supposed to be any landlocked properties in Colorado. So
then it basically becomes part of B's property. Then,
well, the easement is, B has an easement to go through these people's property. He doesn't own the land underneath it. He just has a right of use, a right to use somebody's property for a particular purpose, right? Yeah.
At the risk of sounding dumb, I just want to make sure I'm understanding this. Is this as if like, here's a street, right, and then there's a house, and that's a long driveway next to it? Is that what that's?
Yeah.
That is? Okay, and then that's the house behind. Okay, I just want to make sure I was understanding it correctly.
Down in Ken Carl, they have what they call flag lots, where they'll have, this lot is facing the street, and then they have a flag lot behind it, where They have an easement to go through his property and get to their property back here. And people hate them. If you have a flag lot, it's worth 20% less than the one in front of it, typically. It's called a flag lot with an easement to get back there to it. Easements can be used for many, many different things. Like we talked, the next one, an easement in gross, looking back in the book again, under easements. An easement in gross would be like a utility easement. I have a property and somebody put a billboard on it. They have a gross easement to go service that billboard. They don't have to ask my permission. They have a right to procure their interest. Utilities are an easement in gross. One way to remember it. Utilities kind of gross, easement in gross for utilities. And they can come by and work on the utilities in our front yard. They don't have to knock on the door or tell us a darn thing. They just start doing it. They have a right of procurement when you have an interest in a property. Let's jump down to adverse possession. Adverse possession. And this is essentially squatter's rights, where you live on a property long enough you end up owning it. And you end up owning it. So let's read this. Adverse possession. Adverse possession is the right of an occupant of land to acquire superior title against the owner of record without the owner's concurrence, provided the occupancy has been actual, notorious, hostile, visible, and continuous for a required statutory period. This right of adverse possession can be inherited, but there can be no intervening tenants. We'll talk about that too. And in Colorado, it's 18 years. If you live on that property for 18 years, you could end up owning it. Does that mean I can rent a property for 18 years and end up owning it? No, because I have the permission of the owner. If I have the owner's permission, that's the end of my right for adverse possession. Or if he kicks me out, either gives me possession or kicks me out. Either way, that cancels my possibility of owning that property. We also have another way that you can get adverse possession, that's paying taxes on a property for 7 years. So for 7 years, I've been paying taxes on it. I bought it at a tax sale. And I end up with that, and I pay the taxes every year on it, because if I don't pay the taxes on it, they're going to foreclose on me. And so after 7 years, I can then get ownership of that property. Now on a tax sale, guys, it's almost impossible to get a house. You'll get land sometimes that's never had a lien on it. But a house, you're going to have a lien on it. And there's no lender out there anywhere that's going to let you walk away with that house for $2,000 when they have a $200,000 lien on it. So sometimes it works with land. Most of the time it doesn't. And it just doesn't work with single-family homes.
So how does
Very rare.
disposition work when that happens?
How does what?
Well, how does disposition of the property work with the person that's holding the tax certificate over a period of time? They think they're gonna get it, and they go on paying those taxes every year, and then how does that work in the end? It goes through foreclosure, it becomes bank-owned, or?
Let's keep talking about it here.
Okay.
Okay? Now again, look at 7 years. With color of title, that's the difference. We have a cloud on a title which very much affects its marketability. But we could have color of title too, where it looks like it's legitimate but may not be. And again, you're going to go and get a quiet title suit to clear up that property, to clear it up. Whether you're doing a house on a regular foreclosure, or you're doing a piece of property on a tax foreclosure, whatever, you'll do a quiet title suit. You'll put the courts, put this before the courts, and the courts will say if anybody has a claim, come forth. And if nobody comes forth, then they award it to the person who went for the quiet title suit. That's how that works. And that clears the title. Okay. So adverse possession. There's a lot of misconstruction, because things are different about that too. Like it says here, I have to live on the property. No, I don't. If I'm a farmer and the farm next to me is abandoned, I can farm that farm next to me. And if nobody stops me, even though I never lived on it, I can claim adverse possession after 18 years.
What proof do you need?
What's that?
What proof do you need, like, from a?
It has to be open, you're not hiding it. And it's notorious, if the owner found out about it, he'd kick me off. But he never does find out about it, and I end up owning it. Let's go to page 7-10. And this last paragraph on 710, let's read this thing, I'll read it. Estates, rights, and interests in such areas shall pass by descent and distribution in the same manner as estates, rights, and interests in land, and may be held, enjoyed, possessed, alienated, conveyed, exchanged, transferred, assigned, demised, released, charged, mortgaged, or otherwise encumbered, devised, and bequeathed in the same manner, upon the same conditions, and for the same uses and purposes as estates, rights, and interests in land, and shall be in all other respects dealt with and treated as estates, rights, and interest in land. So between now and Monday, memorize that. Is that the biggest bunch of garbage you ever heard? You talk about an attorney's paragraph. You know, there is such a thing as a period and a comma, you know? Anyway, I thought I'd read that just for the heck of it.
So we don't need to know that.
You don't need to know that, no. You might want to know the things that are in there, but not that thing, no. Let's go to page 7-11. And let's go to the third paragraph from the bottom, where it talks about common interest community, CIC. When you see that common interest community, what should come to mind?
HOA.
HOAs for what?
Condos.
Condominiums, common interest community. That's the same thing. And down below it talks about a condominium with its common elements. You don't need to know about that CCIOA. And then you have your planned community. Whenever you have a planned community, it's called a PUD, a planned unit development. A planned unit development. A planned unit development. Now, I lived in a house one time. It was a $300-some-thousand house, and my association fees were $6 a month. It was to pay some kid to mow the lawn around the sign out front and keep the sign up. That's called the de minimis PUD. D-I-M-I-N-I-M-U-S. It's a mouthful. De minimis PUD.
The projector is on, by the way.
No, it isn't, is it? Okay. De minimis PUD. And again, what does that mean? It isn't even small. It even sounds small, doesn't it? It's a small, insignificant planned unit development. I lived in another house one time where they had association fees, but they were voluntary. And of course, nobody's going to pay them. And when there's no money, there's no enforcement. De minimis PUD. So when you hear that term, don't go freaking out and asking the lender or the underwriter, what does de minimis mean? You know what it means. And that's such an unusual word that when you hear it, it should echo in your brain what it is. It's an insignificant, small, planned unit development. A de minimis PUD. Let's go over to page 712. Look at the second to last paragraph on page 712. where it says a stock cooperative or cooperative housing corporation is formed as a nonprofit corporation intended to provide each stockholder with the right to occupy a house or an apartment in a building owned or leased by the corporation. Each stockholder receives a, this is the biggie, proprietary lease. Proprietary lease, or right of tenancy document if he's leasing it. But if he bought it, he gets a proprietary lease. You don't have to worry about that right of tenancy document. You're not going to see that again. Okay, let's skip over to chapter 9. Chapter 8 we do in law and practice. Let's go over this just for review on chapter 8. Probably half of you have had it, half of you haven't. Those of you who have had it, you should know it very, very well. Let's see. Let's start off. How many square feet in an acre?
43,560.
43,560. How many acres in a section? 640. How many sections in a township?
36.
What are the school districts?
16 and 36.
16 and 36. What are the east-west boundaries that go north and south?
Range line,
What are the east-west north-south boundaries that go east and west?
tier line.
Tier lines. Every township is measured in relationship to what north-south line?
Meridian?
What kind of meridian? Principal meridian, and what east-west line?
Baseline.
A baseline, like Baseline Road coming out of Boulder. And in meets and bounds description, you start and end at the same point of beginning. What is that point of beginning called? Monument. What's the purpose of a monument?
Location.
So the location of the lot. And how do we measure heights and depths of a property?
Yeah.
A datum or benchmark. Datum or benchmark. That's what you're going to get in law and practice, guys. And they were halfway through that part of that couple hours. They were freaking. Everybody does. But look at them now. They've got it. And that's how you're going to have it too. You guys will nail it. Okay, now let's talk about deeds. Chapter 9. And let's go over to page 9-5.
Oh.
9-5, on top of the page, we have the 4 types of deeds. And you gotta know these. Forget the state exam, you gotta know them for real practice. The state exam, of course, but for real practice. You have a general warranty deed, special warranty deed, bargain and sale deed, and quitclaim deed. Now, 2 of those deeds have the word warranty in them. What is a warranty? A warranty is a promise or guarantee. A promise or guarantee is what a warranty is. It's a covenant, promise, guarantee. And notice there's only 2 types of deeds that have warranties. A general warranty deed and a special warranty deed. Now, the general warranty deed is the most common of all deeds, and it's also our default provision. If in our contract we don't put down what type of deed is being given, it will default to a general warranty deed. General warranty deed. Let's look down at the very bottom of page 9-5 and look at a special warranty deed. A special warranty deed has 2 promises. You can write this down or just highlight it. I make 2 promises when I give a special warranty deed. I did receive a deed. I did receive a deed, and I've done nothing to damage that deed since I've owned it. A special warranty deed. I've done nothing to damage that deed since I've owned it. When you sell your properties, you want to give a special warranty deed. You want to get a general warranty deed because it has 5 promises. It's the strongest of all deeds. It's the most common of all deeds. is the default provision. If we don't put in a contract what type of deed, it will default to general warranty deed. What other default provisions we talked about?
Transbroker. If we don't.
Transaction, broker, or agent?
And then
What's that? The tenants in common. If we don't put down how we're taking title, it's a default to tenants in common. The third default provision is a general warranty deed. If you leave that blank, it will default to a general warranty deed. Now, let's look at general warranty deed. Several questions on the state exam about general warranty deed. First one is going to be covenant of season. See that word season? That means possession. You're going to have a question on the state exam that says the word season is generally associated with a general warranty deed. You're going to smile when you see that one? General warranty deed. Covenant of season. What I'm transferring to you, I have the right to transfer. Covenant of season. That's the first promise, the first guarantee of a general warranty deed. The second is the covenant against encumbrances. What is an encumbrance? The definition. An encumbrance is anything that limits our use, title interest, or value. An encumbrance is anything that limits our use, title interest, or value. Anything that limits our use, title interest, or value. What type of encumbrances would limit our use?
Zoning,
What's that?
zoning,
Zoning would probably be top of the list. What would it even be above that?
Taxes.
Homeowners associations. Homeowners associations. And again, so what other things would limit our use? Would taxes limit our use? No.
easements.
Encroachments would limit our use. How about setbacks? I can't build right on the street, have to build in 20 feet. I can't build right on my neighbor's lot, I have to build in. Those are encumbrances that limit my use. Then, yeah,
When we're buying a property, say for instance for a fix and flip, where do we go to find out, yes, it's zoned duplex, that's fine, what are the setbacks? Like where would we find that information?
it's in your survey. And before
Well, so
that, before,
What if you're wanting to make an offer and you don't have access to a survey?
well, it's gonna be subject to the survey in your contract. There's a place you can say, subject to the survey, you want the survey within a week or two. And if there's a home on that property, any type of building, there definitely was a survey, or the county or city would not have given them a building permit. So you can go on that survey and find out if there's any encroachments or what's going on. And if it looks like there are, then you get what? An ILC, an Improvement Location Certificate. Costs a couple $100, and a surveyor will come out and tell you if looks like the neighbor's fence is encroaching on my side a couple of feet. Well, you'll order an ILC to see if that encroachment is affecting your use. Yeah.
And I'm sorry, just for further clarification, so again, I'm looking to see, okay, there's a house there now, but if we put in a duplex, because again, we know it's zoned duplex, and we need to know what are the setbacks, and so you're saying the survey will tell us what's allowed by the
Well, the
county?
planning division, if you want it spelled out, go to the planning commission,
Got it.
okay? And that'll tell you where, they'll give you all that kind of stuff. And they'll probably show you the survey too.
Okay.
So, I mean, all this information is readily available. And if you get hung up, you can call up your lender, you can call up your title person, and they'll help you with this stuff too. She's a lender. Anyway. Now you can tell them.
Well,
Anyway.
Well, if you're paying cash, you're not gonna have a lender, you know, and so, anyway,
Yeah.
yeah, all right, thank you, planning division, that's what I mean.
Okay.
Carry
So,
on.
so those are things, you guys. So those are things that limit our use. Now, what would limit our title interest? Any type of lien. What is a lien? It's a monetary amount that affects our property. A lien, it limits our title interest. Does it limit our use? No. A lease does not limit our use. Whether I have it 100% paid for or I owe 100%, my use is exactly the same. Okay? Everybody see that? So anything that limits our use, zoning, building codes, setbacks, encroachments, title interest, liens, or value. I'm next to a busy street. I'm next to a railroad track. I'm next to a light rail. Things that, again, affect or limit my value on the property. All of those are encumbrances. The last one you can't do anything about except move. So, you want to get a general warranty deed, you want to give a special warranty deed. And then we have the covenant of quiet enjoyment. Where have we heard that before?
Bundle of rights.
The bundle of rights, the bundle of rights. Let's do it. You guys, nobody answers except one person. Let's write down the bundle of rights. There's 5 of them. The first right is always going to be possession. Possession, bundle of rights, possession. Number 2, use and control for any legal purpose. Use and control for any legal purpose. Possession, use and control for any legal purpose. Quiet enjoyment. We have a right to quietly inhabit our property. Possession, use and control for any legal purpose. Quiet enjoyment. We have a right to quietly inhabit our property. Then exclusion is number 4. We can keep people out. And number 5 is disposition. You can sell your property or put a lien on it. You can encumber it or sell it. Possession, use and control for any legal purpose. Quiet enjoyment, exclusion, and disposition. Any questions on that? So that's one quiet enjoyment, the right to quietly inhabit our property. Here's another one in a general warranty deed. It means something completely different. If someone usurps, a third party comes along and say they have an interest other than what I say I'm giving you, I will go to court, I'll provide whatever documents I have to, I'll do whatever I can to protect this interest I'm giving you. I'm selling you or giving you. And I will do that through the covenant of further assurance. I'll provide whatever documents I have to, I'll even go to court. And that's again the covenant of further assurance. So those two go hand in hand, quiet enjoyment and further assurance. Not insurance, assurance. I'm assuring you that what I transferred to you, I have the right to transfer. Then the last one is warranty forever. We warrant the property forever in the past, which subsequently warrants it forever in the future. Forever in the past, which subsequently warrants it forever in the future. And do yourself a favor, guys. How well should you know this? As well as I just said it. Do yourself a favor. Spend time learning these deeds so you can talk intelligently to people about it. You'll be in closings talking to people about different types of deeds, and that closing lady a lot of times doesn't even know what the deeds are. So again, there's 5 warranties in a general warranty deed. There's 2 warranties in a special warranty deed. I did receive a deed and I've done nothing to damage the property as long as I've had it. Let's go to page 9-6.
I have a question real fast. Why are you saying you should give a special warranty deed and receive a general warranty deed?
When I give a special warranty deed, I'm just making 2 promises. I did receive a deed and I've done nothing to damage it since I've owned it. But I got a general warranty deed when I bought it, because I insisted on a general warranty deed. I'm still only gonna give a special warranty deed. So I sold my house, let's say, and this guy wants to do something with his house that the guy before me screwed up on. Okay, he did something that prevented this guy from maybe developing the property or doing something with this property, and nobody caught it till I sold the house to this guy after me, and I gave him a special warranty deed. Well, this guy who wants to do this thing is going to sue me, the guy behind me, and he's going to say, and I'm going to say, wait a minute, I'm only warranty you for the time I've owned it. I'm not responsible for that clown before me. I have no responsibility at all. I did receive a deed. I have done nothing to damage the deed while the time I've owned this property. That's why you give a special warranty deed, you get a general warranty deed. Is that a double standard? Yes, it is. But you've learned the difference now. You've learned the difference. Use what you've learned. And learn what these are all about. Very important. Let's go to the top of page 9-6 and a bargain and sale deed. A bargain and sale deed may or may not have warranties, and if they do, they're merely implied warranties. Bargain and sale deed, they're only implied warranties. They may or may not really have anything to do. Sometimes they're used in place of a quitclaim deed or some other type of deed. We haven't used them very much in Colorado at all. But again, it's called a bargain and sale deed. And the way you can remember it, it only has implied warranties. It's a bunch of BS. So again, a bargain and sale deed only has implied warranties. Then you have a quitclaim deed, and remember, that's spelled with a T, not a CK, a T. When you give somebody a quitclaim deed, you are quitting your claim to that property. You're actually quitting your claim to that property. So, what is the strongest of all deeds? General warranty deed. Which deed transfers the most amount of ownership interest? They all transfer the same. It's just that with a general warranty deed, I'm making 5 promises. With a quitclaim deed, I'm not making any promises at all, but I'm transferring all the ownership interest I have, if I have any. So a quitclaim deed. The most common of all deeds is a general warranty deed because it's the default provision if you leave it blank in a contract. Then, the elements of a deed. Down at the bottom of the page on 9-6, it has to be a written instrument. A deed has to be in writing. And a deed for real property, and it's always for real property, has to be in writing or it's void through the statute of frauds, which you guys will know real well here in just a little bit. So it has to be a written instrument. On 9-7, look at that second paragraph. There has to be the parties, the grantor and the grantee. Why not the owner and the buyer? Why do they say grantor and grantee? It could be a gift. He may be giving it away, in which case he's not the seller, is he? But whether he's giving it away or selling it, he's always the grantor. And he's the only one who signs the deed and the deed of trust. The grantee merely accepts it. He does not sign anything. But when there's been delivery and acceptance, that's when the property changes hands. And when does that happen? It happens when the deed's recorded, right? No. No, it's not when the deed's recorded. It's in that closing room when there's been delivery and acceptance. That closing lady passes the deed to your buyer. As soon as he grabs that deed, he owns that house. Then later on, after all said and done, the closing lady will send that deed to be recorded. Why, if it's already changed hands? Why does it matter to get it recorded now?
Constructive notice of the deed
Very good,
switching.
because a constructive notice. We record a deed to give constructive notice. No one on the planet can say that they don't know I own this property. No one on this planet can say that they don't know I own this property. Constructive notice, and there's another way to give constructive notice, and that's to take possession. Two ways to give constructive notice. Record the deed or take possession. Okay. Number 3. Any of that I can say again? Y'all got it?
I have a question, and it's going back a little, I'm sorry. I
Okay.
just didn't get it down. The special warranty deed was, you give it because you have done nothing to damage the property?
I give a special warranty deed because there's only 2 promises. I
Right.
did receive a deed, I've done nothing to damage the deed since I bought it.
And the general warranty deed you get?
You want to get that when you buy a property because it has 5 promises. That's what I want to get when I buy a property.
But like a seller couldn't give a special warranty and the buyer receive a general warranty.
No. No.
And who fills that out in the contract? Both sides of the
The
parties?
buyer does. The buyer's broker fills that out.
Fills that.
And you fill out what kind of contract it is. Just like in the listing broker, you fill out for the listing broker what kind of deed he's going to give. I always put down he's going to give, a special warranty deed. And if I'm working with the buyer, he's going to get a general warranty deed. Now, what if I get a call on that? And the buyer's broker calls me up and says, how come you're just giving a special warranty deed? I'll say, well, that's what the seller prefers. Well, I demand a general warranty deed. He doesn't know what the difference is. You kidding me? He doesn't know like I just told you guys. And what I want to say is that, you know what, did you realize that in the contract, we're insuring over the standard exceptions? What that means that as part of the title policy, you have these 6 promises. You pay anywhere from $60 to $100 for it, the seller does, to include these in the title policy. And it's called insuring over the standard exceptions. Those are the 6 exceptions. Well, I tell that guy on the phone or lady, and I say, but you notice we're insuring over the standard exceptions. They have no clue what I just said. You're doing what? You're insuring over the standard exceptions. And they don't want to sound like an idiot, so they'll go, well, if you'll do that, then fine. We'll take them. Guys, use your knowledge. Use your knowledge. Now, and it's only happened a couple of times, but I have ex-students call me up when we're working on both ends of the deal. And, you know, and the buyers, he hasn't seen, they just now got the contract or whatever. You know, they're working with the seller or whatever, and I'm the listing broker, they're the buyer's broker, and you call me up and you say, why aren't you giving a general warranty deed instead of a special warranty deed? And I say, well, we're insuring over the standard exceptions. I don't know if you noticed that or not. And you say, McCluskey, I took your class. I know what the difference is. I will immediately change it to a general warranty deed. You paid the price to know the difference. You bet. You bet. Is it a game? It's a fun game. It really is. And all you're doing is protecting your people, protecting yourself. Okay? There's nothing wrong with it. It's called knowledge. It's called knowledge. And if you guys get these deeds down, like I've been talking, you're going to be very pleased you did. Because sooner or later you're going to be buying your own house also. You know what you might want to do this weekend is go through your papers on your house or your lease and see what's in there that you recognize now. Let's keep going. Number 3, recital of consideration. What is consideration? Consideration is something of value for something of value. Something of value for something of value. Consideration. Something of value for something of value. You have to have consideration or you don't have a contract. Number 4, words of conveyance. You have to show an intent to convey. You have to show an intent to convey. You have to have a description of the property, a legal description of the property. Let's keep going. Number 6 on page 9-8, a signature. A signature on the deed, and only the grantor signs the deed. Only the grantor signs the deed of trust. Aren't they the same thing? Why'd I separate them? Is that wrong? Are they the same thing, a deed and a deed of trust? Yes, no?
No.
No. Well,
What's-
deed of trust is the mortgage.
The deed of trust is the same thing as a mortgage. I walk into the closing, my people do, and the first thing they sign is a promissory note. I will buy this property, and I'll pay back this loan. And they sign that. And that is the money, it's the evidence of the debt. Then they sign a deed of trust, which is the property, it's the security for the debt. In other states, they have mortgages. Remember, a mortgage is not the money. The mortgage is the property. Great trivia question, okay? The mortgage is not the money. The mortgage is the property. And nobody has a mortgage. You gave it to the lender as security for the debt. So nobody has a mortgage. What do you have? A promissory note, which is what the money is. So you sign this deed of trust, in other states it's a mortgage. Then the lender says, good, you promised to pay back this money and you gave me the security for that debt, here's your deed. So again, the promissory note, the deed of trust in Colorado, mortgage in other states, then we get the deed, then we get the title policy. And between the deed and the title policy, we've got a really good idea of what we just purchased. Don't you ever buy a property without a title insurance policy, or let your people do it. Okay. And then we have delivery and acceptance. We talked about that. Where the heck are we?
Delivery and acceptance.
The delivery and acceptance, and that happens at the closing, in the closing room. That's when it changes hands. Then we have exceptions and restrictions. I'm selling you my property, but I'm restricting from you the mineral rights. I have a small ranch or something. Now I'm going to keep the mineral rights. I'm going to restrict or exempt the mineral rights. Top of the next page, number 9, warranties and covenants. Warranty, guarantee, covenant, a promise, all those mean the same thing. And there's only 2 deeds that definitively have promises. General warranty deed and a special warranty deed. Then we have a date. A date is not essential by any means. It could just be a benchmark date. The contract signed such and such a date. It may or may not even kick in then. But the date. Then the acknowledgement. What's another word for acknowledgement? Notary. Notary. Acknowledgement and notary are the same thing. I am who I say I am, and I'm giving my signature voluntarily. That's what an acknowledgement says. Acknowledgement, the notary. Look at number 12, recording. We talked about that. No state has a requirement for recording a deed. You don't have to record a deed. So let's read this in the bottom down here. Recording. A deed is valid even if it's not recorded. The wording of the Colorado recording statute is permissive. May be recorded rather than must be recorded. Recording offers a twofold benefit. It protects an innocent purchaser or encumbrancer, lender, from acting in ignorance of an unrecorded instrument. and it provides constructive notice. Boy, highlight that constructive notice, guys. A legally conclusive presumption that all persons have knowledge of recorded instruments. It is in the grantee's best interest to record the deed immediately. But we don't record. What do we do? After closing, we jump in our cars and run up to the county. The closing lady has all those envelopes there with the checks in them. She just mails them out. Then a couple weeks or a couple months later, they start coming back to you. And constructive notice is a legally conclusive presumption that all persons have knowledge of recorded instruments. It is in the grantee's best interest to record the deed immediately. And lack of knowledge does not invalidate constructive notice. A recorded deed that is not acknowledged still serves notice of subsequent purchasers. We don't have to have it notarized either. Isn't that something? We don't have to have it notarized either. In some states, they won't let you record a deed unless it's notarized, but not in Colorado. It doesn't have to be notarized, and it doesn't have to be recorded. Okay, look on top of page 910. In addition to constructive notice, a purchaser or encumbrancer may have actual notice of another's rights or claims. For instance, a purchaser is presumed to have actual notice of all rights and claims of parties in possession of the property, so that even if the right or claim is unrecorded, the purchaser cannot defeat it. Okay, so we talked about deeds, now title. Let's talk about titles. Let's go to chapter 10. And there's 3 types of title insurance we recognize in Colorado. 3 types that we use. The first one is an abstract and opinion. Between and opinion, put down attorney's opinion. An abstract and attorney's opinion. An abstract and attorney's opinion. Now what this does, guaranteed question, they're going to say, it shows the chain or history of ownership of a property. We used to use them 50, 60 years ago. We don't use them anymore because that's all it does. It just shows the chain or history of ownership. It may not show exactly who was owning it at the time or subsequent owners or whatever. So it's an abstract and attorney's opinion is what we recognize in Colorado. We ordered a title policy that showed a history of ownership. This is more than likely abstract and opinion. Expect to see that question. Then go to the next page. Let's just jump down to title insurance, the actual title insurance. Title insurance. And what's really strange in this is the only, see those number 1, 2, 3, 4 below title insurance? Those are the standard exceptions. Remember I told you that's how I kind of baffle the brokers who call me and want to get a general warranty deed? I'll say that we're insuring over the standard exceptions. They only mention 4 here, there's actually 6. And we'll see them when we go over the purchase agreement the next session. So title insurance, we have abstract and attorney's opinion. That's one. Title insurance is another one. Top of page 10-3, we have the owner's versus mortgagee's policy. The real expensive one is done by the owner or the seller. It's called the owner's policy or the seller's policy. The owner's policy or the seller's policy. Now, that's the expensive one. Say it runs about $2,000, okay? And what happens is that the lender also needs a title insurance policy. The mortgagee, remember the lender is the mortgagee, the borrower is the mortgagor. The money, the mortgagee, the money. Way to remember that. Who's the mortgagee? The lender, the money. Who's the mortgagor? The borrower. The borrower. Now, we have so the lender comes up to me and says, Jim, well, we appreciate you coming to us for the business, for getting your loan with us, but we have a dilemma. The seller paid for a title insurance policy, he paid $2,000 for it. And we need one also to protect your loan, actually to protect us in making your loan. We're gonna sell your loan to the secondary market. Fannie Mae, Freddie Mac, Ginnie Mae, or Farmer Mac. And the only way they will buy it is if it's in first position. And so we need you to buy another insurance policy to protect us. Now you can get a brand new one that's gonna cost $2,000, or you can get a spin-off policy that's gonna cost $200. What do you wanna do? It's such a no-brainer, guys, that nobody ever asks the borrower to do that. It just shows up on the closing statement as two different title insurance policies. There's the owner's policy that protects your marketability in your property, and then there's the lender's policy, the mortgagee's policy, that allows the lender to sell that loan to the secondary market. So there's two types of title policies typically in every loan that you do. And I'll tell you what, if you're sitting at that closing table and somebody says, why are there two title insurance policies, you're gonna be the only one sitting there who knows. Unless the other broker came from this class. Because this isn't something that pounded into people what these are.
Can you repeat that on the owners, on the contract, the owners, title insurance?
There's the owner's title insurance policy, or it could be called the seller's policy. When we get to closing, you'll know that really, really well. The owner's policy or the seller's policy, and that's the expensive one, let's say it costs $2,000. Then the lender, the mortgagee, has a policy also. And the buyer, the mortgagor, is the one who pays for the mortgagee's policy. And he gets a spin-off policy typically. Costs just a fraction of what the seller's policy is. I can say that again even. Everybody okay with that? A good way to explain it, and you're going to see some tricky questions on that. Don't let them get you. Okay, now. Then on B, on page 10.3, you have a title insurance commitment. This is not a title insurance policy per se. What it is called a TBD. It's the actual title insurance policy without the people's name on it. That's what's to be determined, putting the people's name on it. It usually costs about $100, and it goes toward the purchase of the owner's policy. But it's not the actual policy itself. It is the insurance policy, but it's not what's being used for the title insurance policy because the names aren't on it. It's a TBD, to be determined. What's to be determined? The names of the purchasers of that property. Okay. Let's go over to 10-4. 10-4. Look at the second paragraph on top of page 10-4. Title companies give sufficient information in the form of an ownership and encumbrance report, and O&E is what this is called, or O&E, to allow a licensee who has a listing to perform most necessary functions. Although title companies must also charge for O&Es, the cost is often far less than that of a TBD commitment. They're $5. And you go online and you get them from a title company. And they're going to charge you $5 for an ownership and encumbrance report. What do you think that shows us?
Encroachments.
No. It's going to show us the owners, ownership, who's on title, and what
Encumbrance.
liens,
Yeah, liens.
those type of encumbrances that are on that property. And you always pull one of those before you go take a listing on a property. You pull up the county records, you pull up an O&E to make sure that you're you can't have too much information about that property before you go take that listing.
I'm confused with an ILC, which is wacky.
Well, an ILC, of course, is, you know,
Yeah.
that's what, improvement location certificate.
Yeah.
This is an O&E, ILC,
Mhm.
you know, CC&Rs, all these letters, guys, drive you nuts so. But that's how we work in this industry. We don't call things, ownership and encumbrance report. We call it an O&E. You've gotta know what it is, and you will, and you will. Let's go to page 10-5. Talks about the good funds law right in the middle of the page, and see that dark print a couple paragraphs below that? What does good funds mean? It's available for immediate withdrawal as a matter of right. I can get my hands on it today. Now the third type that we have what? An abstract and opinion, the actual title insurance policy, and the third type, look on page 10-6, is a Torrance certificate. Second to last paragraph down there. Now a Torrance certificate works like this. There was this guy named Torrance, and he was in Great Britain, in England. And if someone found a ship that was abandoned, you could take it on shore, and it works just like a quiet title suit. The city or whatever, the newspaper will say, put an article in the local newspaper saying if anybody has a claim for this ship, on this ship, come forth or you're gonna lose it. That's what we use in Colorado. Only 10 states use this. We use it out on the eastern plains quite a bit. Some of those counties are only open a couple days during the month. No title company's gonna use those records as being worth a darn, so they'll use a quiet title suit through what's called a Torrance certificate. Ownership and encumbrance, actual title insurance policy, and a Torrance certificate are the three types of title insurance we use in Colorado. Yeah, what's the first one?
Abstract and opinion.
What's that? Abstract and attorney's opinion. You'll never hear attorney again. Abstract and opinion. But just know that that opinion is an attorney's opinion. The actual title insurance policy itself, and then the Torrance certificate. Those are the three types of title policies we accept in Colorado, that we recognize in Colorado. Okay. Let's go to chapter 11, talk about appraisal regulations. On the Colorado portion of the state exam, there are no questions on appraisal, none whatsoever. And again, I'm working right now to get everything back in order again, where we can revive the appraisal industry because it was so destroyed by the federal government in 2010 that we were very close right now to not having any appraisers left. But anyway, keep your eyes on that, and I'll be talking to you more about it too. I'm meeting with the guy on Tuesday, I believe, to get some more information. Just skip chapter 11. Isn't this a good day, all these chapters we're skipping?
Yay.
Let's go to chapter 12. Mortgage loan originators. We spend a lot of time on lending. Okay, so chapter 13. Mortgage loan originators. To give you a little bit of background on this, I was on the board of directors of the Colorado Association of Mortgage Brokers in the year 2000, when one of the state representatives from Colorado his wife had been jacked around a little bit, I guess, by a mortgage broker, so he was loaded for bear. And he interrupted one of our meetings one time and he said, "I'm a state senator, and if you guys don't license yourselves, we'll do it for you." At that point, all the states were licensed except for Alaska, Montana, Wyoming, and Colorado. And we said, cool, we'll do it. And we put in hundreds of man hours and putting together this sunset review. And it had to be before the state legislature before July 1st of the year 2000. And it sits in there for 16 months. And so in November of 2001, we pulled it out, and it was going to be one of the first things brought before the state in 2002. Well, what happened is that we lost it. The head of the Senate, called Tanzanaka, he was out of Fort Collins, had it up in his desk up there, we found out. And one of the board members called me up, and he said, we've called up there, we can't get through, we're having a heck of a time, could you give him a call? I said, I can't make any more progress than you can. But I did give him a call and I lucked out. I got his executive secretary, I told him what the problem was. She apologized right and left, and we had it in our hands the next day. But it was too late to put it before the state in 2002. Plus we had a lot of opposition from the banks and the Governor Owens then did not want mortgage brokers to be licensed. And so in 2002, what we did, you always have the Democrats when you're going to add more government. So we started whining and dining the Republicans to get them on our side. And it's going really well, we thought. And the last day of session, it went before this one committee that was headed by a Democrat. And we went, cool, we got it made. And this guy stood up there, and this is pretty much exactly what he said. He said, because of the bipartisanship of this issue, in other words, we didn't kiss the Democrats hard enough. We were too busy kissing the Republicans. He said, for the first time in my life, I'm voting against something I'm for, and killed it in 2003. At the start of 2004, first week of session, we got a letter from Governor Owens saying, if anything hits my desk about licensing mortgage brokers, I'm going to veto it. So that killed 2004. We kind of took a break in 2005, kind of just catch our breath. We had so much time and effort. We're all just get consumed on this thing to make it happen. And so what happened is during that time, in 2005, Governor Owens threw this big party down at his mansion, and some of us went to it. And really just top-notch, of course, the governor's mansion thing. And what happened is that Governor Owens had a few too many. He was kind of over in the corner by himself. So we went over there and cornered him. And we went up to him and we said, hey, Gov. We didn't say Gov, by the way. We said, we're at the mortgage brokers. And he said, I know who you are. He said, guys, I don't have the funding to start this thing. And there's just no way I can approve it. I just don't have the funds. And I said, well, why don't you do this? Why don't you... well, it was, we said it, not just me. I said, why don't we do this? Why don't we register mortgage brokers? And he kind of, went, register? That might be a good halfway measure. And we didn't let him forget it. We reminded him about it. So in 2006, mortgage brokers were registered. Whatever that means. You register your dog. Well, we got mortgage brokers registered. 10,500 of them. Then Governor Owens was out of office and the new governor came in and we had licensing in 2008. Worst year in history. Terrible timing, but we got them okay in 2008. And in 2008, 4,500 mortgage brokers got licensed. Remember, 10,500 got registered. So in those 2 years, we lost 6,500 mortgage brokers in Colorado. Anyway, so that's how we got mortgage brokers licensed. So it was really an uphill struggle, to say the least. And now we have to work on getting inspectors licensed. Inspectors are not licensed. And out of anybody who we have in our industry, inspectors more so than anybody should be licensed because they're in that house sometimes 4 and 5 hours. They can just ransack that house if they wanted to. Let's go to chapter 14 and talk about water rights. Water rights. When they rewrote this, it's probably 5 years ago, I would think. And what they did, they took out the pages that had the questions that were on the state exam. So I'm gonna go over the questions that are on the state exam, not word for word, but I'm gonna have what was missing. So let's start at number 1 up here. This is on page 14-1. Okay, here we go, 14, and water rights. So let's read this. All water in natural surface streams and groundwater and related aquifers, and aquifers underground storage, aquifers, called tributary groundwater in Colorado is owned by the public. All water is owned by the public in Colorado and is subject to the doctrine of prior appropriation. Doctrine of prior appropriation means first in time is first in right. The first one to use the water has the senior usage. Everybody who comes after him falls in behind him. So again, doctrine of prior appropriation. First in time is first in right. Where else do we see this doctrine of prior appropriation? On liens, when recording our deeds. The first one to be paid off is the one in first position. Recording liens. First in time is first in right. Doctrine of prior appropriation. Groundwater other than tributary groundwater is allocated by different rules as described below. There is a rebuttable presumption under Colorado law that all surface water and groundwater in Colorado is tributary to a natural surface stream. A water right is the right to use a portion of the state's water. Big star by that. A water right does not represent ownership of the water. It is a right to use a certain amount of water for a particular purpose under the restrictions stated in the court decree or well permit defining the water right. How about a well permit? Is a well a water right?
No.
No, it's a usage. It's a water usage. Calling a well a water right is like calling the pipes coming into your house bringing water a water right. No, it isn't. It's a utility. And so is a well. It's not a water right, it's a utility. Now some big wells, some of them are commercial, and they are a water right, but it's very rare. And the doctrine, next paragraph, the doctrine of prior appropriation is adopted and recognized in the Colorado Constitution and the state statute. Prior appropriation means that the first user to divert water from a stream and put the water to beneficial usage has a prior right to that source of water compared to the latter users. Under the prior appropriation system, water users do not share the burden of shortages. The prior user is entitled to divert the full amount of water to meet his or her entire water needs before the next junior user is allowed to divert any water. Water is appropriated, and a water right is created by actions of the person who makes the appropriation. Physical diversion of water from a stream or a tributary aquifer and application of that water to beneficial use creates a water right. No further administrative or judicial action is necessary. So the first one to use it is the one who has the first right to that water right. And in some of our water rights in Colorado, that water right is far more valuable than the entire property. Talking about wells down in central Denver, underneath the Brown Palace, they have a 600-foot well that goes down right in the middle of downtown. You think, well, that must be really polluted. Sweetest water you ever had. And if you go into the Brown Palace and you go over to their drinking fountains, they have a little thing in there on the drinking fountain. This comes from our 600-foot well. And all the water used at the Brown Palace comes from that well. So next time you're down there with your husband or your kids, take a minute, show them. Everybody's gonna think you're so smart, all these things you're doing out there, little, going past all these things, you know, they're just talking about them. That's what this is, that's what that is. But anyway, so the Brown Palace uses all of its water from a 600-foot well right in the middle of downtown. 1, 2, 3, fourth paragraph down on page 14.2. Water rights are administered, meaning that they are enforced by the state engineer's office. State engineer's office is where you go get a well permit. Highlight that. Each water division has a division engineer's office that administers water rights in that division. Each division engineer supervises a number of water commissioners, who are the people who actually tell water users whether they can legally divert water under the water right at any given time. Water commissioners are the local police of the water administrative system. Groundwater in Colorado is allocated under several different rules, depending upon the physical characteristics. Now, for all intent, let's read this last paragraph on 14.3. A well is any structure or device used for the purpose or with the effect of obtaining groundwater for beneficial use from an aquifer, underground storage. A permit issued by the state engineer's office is required to construct a well. Except in designated groundwater basins where the well permit is issued by the General Water Commission, the state engineer's office maintains records of all well permits issued in the state. They had a question at one time on the state exam, where they say, where can you get your well permit? And they had A, Groundwater Commission, and the other one, of course, would be the state engineer's office. Both of those are equally correct. If they have that again, remember the state engineer's office is the main one. Okay, like I say, there's going to be, like I say, anywhere from 8 to 15 questions on the state exam that are just wrong. Some of them are really wrong. A lot of them are just test questions that they're just thrown in there that they may use later. But, again, expect to see some mistakes on that state exam.
Are they on purpose mistakes?
You think the mistakes in this book are on purpose? No, it's just they just happen. We're human, you know. We make mistakes. So, look on top of page 14.4. This is a very obscure law in Colorado. And this is something you should really be aware of. Appraisers really have to be aware of it. It's called Senate Bill 35. And the Senate Bill 35 said this: any land that was subdivided before June of 1972 is automatically, you can get a well permit on it. At least you have a right to get a well permit. Any land that was subdivided after June of 1972, you have to have a minimum of 35 acres to get a well permit. That's why we have these 35 and 40 acre mini ranchettes all over. This is because of this Senate Bill 35. So again, June 1st of 1972, you don't need to know that well, but just be aware of it out there. People might be talking about it. You know, why do we have all these 35 acre parcels and everything? It's because of this Senate Bill 35. It doesn't guarantee you that you can get a well permit. I had a student one time, and he had 51 acres up in Bear Creek in Evergreen. And the guy next to him had a parcel that had 32 acres. And so he went to him, and do you remember we were studying this? What timing? And asked him, he said, I tell you what, you know, I'd like to have those 3 acres next to you there. I'll tell you what, I'll give you $24,000 and I'll let you have access to the national park behind me. And so he came to class and we were talking about this. I said, you know why he wants those 3 acres? Because his 32 acres is worthless. Totally worthless. He can't put a well on it. And that's why he wants those 3 acres. And he a big smile on his face. And he went and worked something out with that guy, made a small fortune on that. That's very valuable land, plus access to the national park, everything. So again, taking this course, guys, take it to heart. You never know what part of this course you're gonna be using, but you will use it. I wish we had to take this class before we graduated high school. We'd eliminate a lot of problems in our lives if that would have happened. But that's okay, we can start now. Let's go over to 14.6. Disclosure of potable water source. We've talked about this a couple times today, actually, even. On and after January 1st, 2008, Colorado law requires that a listing contract for sale or seller's property disclosure for residential land and residential improvements disclose in boldface type the source of potable or potable water for the property, which can be one of the following: a well, in which case a copy of the current well permit, if one is available, is to be provided. We'll talk about that when we do the sales contract. Water provided, in which case the name and other information regarding the water provider is to be provided. Or neither a well nor the water provided, in which case the source of the water is to be provided. Again, we have to say where we're getting our water from and what is the possibility of continued availability. And look at page 14.7, there's the statement right there in italics, or you want to call it, in bold print. Let's go over to page 1412, 1413. You guys don't need to know any of these. If you do know any of these, if you want to know any of these, the ones you need to know are in the glossary. They're in the glossary. So, now those of you who have been here, this is most of you, your third day, and actually this is the accelerated class, so it's your sixth day. You can now get your glossary disc. Okay, Jennifer's got a bunch of them sitting up there. We give them to you. So, pick those up so you have them when you're driving around so you can listen to it.
I think they're up there now.
There's
a couple.
Oh, okay, there they are right there. Now, you do have to give a testimony on Google about us. I like to say you have to give a good one. I can't say that. Hopefully you will, hopefully you will. But you have to give, and if you don't know how to do it, ask Jennifer. She'll show you how to. But do not just take that disc and not give us one. Really would appreciate it. So again, this is our gift to you, and we're going to you have 4 more coming your way. 3 more coming your way, actually, as you're going through the course. So, let's go to page 1413. Look in the middle of the page, we have water usage. Water usage. This is part of the things you're going to see on the state exam. Water usage. There are 4 types of water use. This isn't water rights, water usage. The number 1 most important thing, yeah.
Where are you
Where are you at?
I'm on 1413. 1413 in both books. It says, you don't have it?
No, it's there.
You said not water right?
I said not water rights. I said water, not water rights, water usage. Write that down, water usage. It's not water rights. And there are 4 types of water usage. The number 1 water usage, of course, is domestic or household. Domestic or household. Number 1 use. The number 2 and 3 uses could be either commercial/industrial or agricultural. Commercial/industrial or agricultural. So number 1, domestic or household. Number 2, commercial, industrial, or agricultural. Then the last one is recreational. Recreational, so again, domestic or household, commercial/industrial, agricultural, or recreational. So you guys, so they decide that, and then they're running out of water. Let's say Wheat Ridge is running out of water. And they say, we're gonna have to cut back on this. We're going to move the agricultural ahead of the commercial. And the way they do that is they condemn that senior water usage. They condemn that senior water usage. So they would condemn the commercial industrial and move the agricultural ahead of it. By condemnation. There are 4 ways we use condemnation in Colorado. One is this water usage. What are the other 3? Eminent domain through condemnation. How does the government create rights of ways?
Condemnation.
Inverse condemnation. Inverse condemnation. So let's do it again. We have water usage, eminent domain, inverse condemnation, and the next one I call blighted building, just because of the alliteration. An old beat up building, you condemn it and tear it down. A blighted building.
How do you spell that?
B-L-I-G-H-T-E-D. And you can call it anything you want to. That's kind of what I call it. Just because of that alliteration, it's easy to remember. So there's 4 ways to use condemnation. Water usage, eminent domain, inverse condemnation, and a blighted building. Blighted building. Okay, let's go over to page 15.3. This whole chapter again is about brokerage relationships, agency, transaction broker. Again, they love repeating themselves a lot of times. But let's go down to 15.3 and look at that last paragraph down there. The last big paragraph on that page, where it says there are 3 kinds of agents. Universal agents, general agents, and special agents. Everybody see that? Boy, highlight this, guys. A universal agent is I have a lot of power. I can act as if I am that person. I can sell his car. I can sell everything he owns. I have universal agency. Usually, a lot of times an attorney will work as a universal agent. Then we have general agents. That's generally considered a property manager is a general agent. Property manager, general agent. Then we have a special agent or single agent. You're just selling the guy's house. So the 3 types of agency, all agency falls under those 3 categories. Universal agent, general agent, and special agent. (16.1). Are we burning this book today or what? 16.1. Listings. We've covered this so many times, and we're going to cover it again. Let's zip through this listings. Every listing has to have what? A beginning date and expiry date, ending date. Every listing has to have a beginning date and ending date. Look at the last paragraph on this page, 16.1. Colorado listing agreements provide that property sold within a holdover period after the listing term to any party with whom the listing broker negotiated and whose name the broker submitted to the owner in writing entitles the broker to a commission unless the property is frequently listed with another broker. Now, let's talk about this a little bit. I have a friend of mine, and what happened, she was over at one of her friends. I know both these people. They're both brokers, and they're talking. And he said something like, "Well, I'm thinking about selling my house." And my friend said, "Really? I've got a buyer for it. Let me sell it." He said, "Great. Mail me over the stuff, and I'll sign it and get it back to you." So she did. Sent over all the papers and everything, and she sent them back to him, or he sent them back to her, and didn't sign the listing agreement. Signed everything else. And so she called him up and said, "You didn't sign the listing agreement." He said, "Oh shoot, next time we're together I'll get it." And he never did. And she sold the house for the guy, and she called me up and she said, "This guy owes me $10,000, he only paid me $2,000. After she told me about she never had a signed listing agreement. I said, "You're lucky he paid you the $2,000. He said, "Well, I'm gonna sue him, blah, blah, blah." I said, "Good luck." She's not even gonna be able to find a lawyer to take the action on it, because again, it has to be signed. I know both these people, and I also know that a few years before this happened, he asked her to marry him, and she said no. So there's more to the story, more to the story. Okay, let's just go through these. A net listing. I have a set amount plus I pay the utilities. That's a net listing. I have a set amount, I pay the utilities and upkeep. Net listing. I have a set amount, I pay the utilities, upkeep, and taxes. That's a net or triple net lease. Net or triple net lease. That can be residential or commercial. Set amount, I pay the taxes. Set amount, I pay the taxes and upkeep. Set amount, I pay the taxes, upkeep, and utilities. A net lease. It subsidizes the owner's expenses. Put that along the side there too. It subsidizes the owner's expenses. Then, an open listing. An open listing. You know what, guys? That's a net lease. That's not a net listing. I'm about ready to call it a day too. Okay, what a net listing is. That was a good preview for what what I was just talking about is. That's a net lease. A net listing is something else. That's where the people say, "We only want $300,000 for our house. Anything you can get over and above that you can keep." That's a net listing. Colorado is one of the very few states that will have a net listing, because it could encourage the broker to be dishonest. A net listing. Where again, a net lease, very similar to it in sounding, is where I'm subsidizing the owner's expenses when I'm renting a property. So net listing. Then we have an open listing. I list my home with all you guys, so there's 40 of you out there selling my house. If I sell it, nobody gets paid. Would you really have any incentive to sell my house? Probably not. Not only that, but I could put in the MLS and expose it to thousands of brokers. So you're not going to use an open listing in Denver, ever. The exclusive broker listing. Exclusive agency or exclusive broker listing. No matter who sells that house, I get paid. Unless the seller sells it himself, then nobody gets paid. That's, again, an exclusive broker listing. In Colorado, it's called either exclusive agency listing or exclusive broker listing. I'm looking at C toward the bottom of the page, 16.2. Then we have the most widely used type of listing. That's the exclusive right to sell listing. No matter who sells that property, we get paid. Even if the seller sells it himself, we get paid. Exclusive right to sell listing. Then we have multiple listing. That's just a marketing tool, the MLS, multiple listing service. Multiple listing service, MLS. Then we have the right to buy agreement. Remember, I have the buyer, and I have in an agency agreement where no matter who sells him a house, I get paid. Even if he finds one himself, I get paid. And that's a buyer agency agreement. So those are some of the listings we can have. Let's go to page 16.4, top of the page, change of status. That listing contract you did, the listing contract you did was actually for an agent. We took that listing as an agent. We're gonna fill out the purchase contract, and we're gonna be working with that person as an agent too. We're gonna have dual agency. I can show these people the property and not have dual agency. It's when I write a contract that I have to make a decision on that dual agency. And I'll do it with this change of status form. We'll talk about this many times because it's pretty confusing. When do we present this change of status form? Remember, I'm writing a contract, dual agent. I'm working with the buyer as an agent, the seller as an agent. When do I present this change of status form? At time of contract. When do I present this change of status form? When the change occurs. When do I present this change of status form? At time of contract, when the change occurs. Okay, you could have all three of those answers. Okay, you could have at least maybe one or two about the status form, the change of status form. So big smile when you see it. You should be fine. Should be fine. Let's go to page 16.6. Closing instructions. That F up there, closing instructions. And what they do, write this after that, they engage the closing entity or closing agent. Engage, they engage the closing entity or the closing agent.
What's this?
Engage, remember that word engage. They engage the closing entity or the closing agent. And those are the, it used to be we threw all of our stuff at the title company and said, see you in a month. Not now, now we work with them. Now we give these closing instructions to make everything flow much, much better. Look on page 16.7, third paragraph from the bottom. Commission approved seller listing contracts require the consent of the seller before a broker may offer commissions splits to cooperative broker. And again, the seller's listing contract requires the consent of the seller. We can't pay a co-op fee without his permission. We can't put a sign in his front yard. We can't put a lockbox on his house without his permission. And where do we get that permission? In the contract. Okay. Well, let's call it a day. Any questions? That was enough for one day.
On
And
the
then
water
some.
rights stuff,
Pardon me?
on the water rights stuff,
The water rights? Okay.
what was that controversy about collecting or not being able to collect water in rain barrels?
This is, okay, let's talk about this a little bit. It always comes up. I should have brought it up myself. But you can't own water in Colorado. In fact, even in your swimming pool, that water's in motion. It's against the law to own water in Colorado because it's owned by everybody in the state of Colorado. And they had a law they overturned just a year and a half ago. You couldn't collect water in a rain barrel. It was the only state who had that law. But now you can, but there's still laws about you doing that.
Yeah, if you cannot, if for some reason, you cannot pull a well permit, or you don't have a well, or you're not near, there's a whole bunch of regulations, because that affects a lot of the properties where we are.
Oh, really?
But yeah,
It does, I bet.
yeah.
What about storage tanks then?
Storage tanks for water?
Yeah,
Why are you storing the water?
well, growing up when we were off the grid, we had a well down by the river and we had a pump that pumped it into a 1,000-gallon tank.
Was the water moving?
Yeah.
Yeah, so,
Homework? You want us to
Not
start the
really.
474s?
no, not the 474s. Guys, if you want to go in your 3-ring binder and keep and reading, plus you have a lot to review, a whole lot to review. Anyway, have a great weekend. I'll see you Monday.
Thank you.